Did you know your social media posts can get you fired? Hi, I am Darren Epstein and I'm a candidate attorney at PPM Attorneys. Today, I'm going to talk about how an employee can be dismissed or suspended for social media posts that are considered unacceptable by their employers. This includes even posts that are personal opinions and are posted outside of working hours. A recent common feature in the news these days are various high-profile individuals facing serious backlash for making some rather ill-advised remarks on social media. The backlash has resulted in the dismissal or resignation of numerous individuals, but how appropriate is this sort of drastic action? Generally, an employer has no right to discipline an employee for conduct outside of work. The exception to this is when there's an apparent connection between the conduct and the employer's business. Employees may claim that disciplinary action against them due to their social media posts are against their constitutional right to freedom of expression. What they fail to realize that the Constitution itself limits the right to freedom of expression and needs to be balanced against various factors including human dignity, equality, and freedom. Their right to privacy is also limited when something is posted on social media as it goes into the public domain and is accessible to a large audience. Any dismissal of an employee must be both procedurally and substantively fair. The obvious question that arises is whether a certain social media post constitutes a fair reason to dismiss an employee. In order to answer this, we need to determine, firstly, that the conduct of an employee on social media caused damage or had the potential to cause damage to the employer's good name and reputation, and secondly, that the conduct of the employee impacted negatively or had the potential to impact negatively on the employer's business. The extent that the conduct has the effect of destroying the trust relationship between the employer and the employee that renders the working relationship intolerable must also be considered. When these factors are present, it may be appropriate for an employer to take disciplinary action against an employee, but this action must still follow proper procedure. It is recommended that an employer has a clear social media policy stating it will be a serious offense if an employee brings the company's name into disrepute. It is better to have a separate social media policy than one that is incorporated in the employment contracts, as it gives the employer more freedom when amending the policies. It must always be remembered that while dismissing an employee for misconduct on social media may be lawful and fair, it is not always the appropriate response. Employees must still always follow due process and remember they are not on an episode of The Apprentice. For more good, clear, precise advice, contact us.